Hi everyone. I think my picture may be frozen, but I'm Rob Davey. I am CEO of Apex and very happy to be moderating our Freedom to Operate Driving Innovation Safely in a Competitive Landscape webinar here today. We've got three very good speakers who hopefully you will be able to see live, who will be taking you through the European landscape as it pertains to the need for freedom to operate, how freedom to operate searches need to be different in Europe, and giving you some details of how Apex can help you with that. To that end, we have three excellent speakers, as I mentioned. First up will be Martin Heiden, who is based here in the UK, is a patent attorney who will give you a little bit of context on the European landscape. Then we have Katarina, who is from the Czech Republic, from our latest Apex member, Harbour IP. So a warm welcome to Katarina, who will be talking to us a little bit about freedom to operate searches. And then Maciej from Poland will be taking us through the Apex freedom to operate model, how we're different, and why it's a good way to make sure that you are innovating safely. First of all, just a little bit about who Apex is. We are a pan-European IP law firm on both prosecution and litigation. We can help you across all jurisdictions in Europe. We're from our 40 offices in 12 different countries. We have 10 member firms who are part of Apex and have over 500 IP experts around Europe who are ready and waiting to help for whatever your IP needs might be. I don't want to make this a big sales pitch, so I'm going to stop there and pass on to the real experts, and going to start with Martin. So Martin, over to you.
Thank you, Rob. So the first subject that I'm going to talk about is essentially the European context of this discussion. Europe has different meanings for different people, and this can have an impact on how you conduct your freedom to operate studies. So what I want to consider before we get into the detail of how we do this is really what are the particular issues of working in Europe. So which Europe are you talking about is the first question. And one aspect of that is which countries are there? Europe means different things to different people. A number of countries have been grouped together and known as Europe, and their groupings can be by geography or politics or international agreement. And these groupings can have different members. Many of them do overlap to a large degree. The part that I haven't put on this list is that many businesses define Europe themselves as to be a grouping of countries, which would include certain countries, exclude certain countries. So what we want to look at firstly is, well, when you say Europe, when most people say Europe, what do they mean? And the first one, unsurprisingly, is geographic Europe, the European geographic continent, which extends from the far north of Norway in the north down to Malta, Cyprus in the south, the far west, which includes Iceland and Ireland and Portugal, to the far east, which includes part of Russia. Traditionally, geographic Europe includes Russia west of the Ural Mountains. So Russia is often considered to be part of Europe, even though, of course, it spans into other continents as well. There are other countries that are traditionally held partially within Europe. Turkey is a good example. The northern part of Turkey, north of the Bosphorus, is within geographic Europe. And so often the southern part is considered to be part of Europe as well. So when people say Europe, this is sort of, if you like, the largest general meaning of that term. And as you can see, it includes countries which often we consider to be either only partially or very much on the fringe areas of Europe. So that's geographic Europe. The next one that we could consider is political Europe. And by that, I mean the European Union. This is a political grouping of countries within geographic Europe that has decided to cooperate in a particular way, particularly in areas of trade and business, and also a lot of their sort of structural areas around that that's done that. So we've got the 27, formerly 28 members of political Europe, of the European Union. All of these obviously are all geographic European countries as well. And these countries have their own law, and they have common areas of law that are controlled and harmonized within the EU. So a lot of people, when they talk about Europe, really are talking about the EU. Although, of course, with recent issues, a lot of people are talking about the EU plus the UK. And then there is the greater area that covers the European Economic Area, which involves Norway and other countries there. So we've got a political Europe there, which means something slightly different to the geographic Europe. And then we come on to, well, there's a Europe identified by international agreement. And probably the most obvious one that we're going to look at in a patent sense, and when you're looking at freedom to operate, is the European Patent Office. On this map, all of the countries in red are members of the European Patent Office. There are currently 38 member countries for the European Patent Convention. So as you can see, it includes countries that are not in the EU. It includes countries that are very much on the periphery of geographic Europe, Turkey being the great example there. But the other thing that you can see about the European Patent Office is it's started to reach outside the geographical area. So countries in North Africa, Morocco, Tunisia, those sorts of countries. And even to some extent, it's reach with the agreements with Cambodia. So obviously that's not Europe, but it is something which is affected by the international agreement that involves Europe, and that's the EPO. So you can see, EPO is not necessarily the same as political Europe, and it's not necessarily the same as geographic Europe. And now, to make life slightly more interesting, we have another version of that, which has recently come about. It's an international agreement, and this is the unitary patent and the Unified Patents Court countries. This is a subset of the EPO countries. The map here shows them. So the lighter blue countries are all of the countries within the EPO that are currently fully up and running as far as the unitary patent is concerned. The yellow countries have nominally agreed on the principle there, but have not implemented the regulation yet. And the countries in red are not going to do that, even though they are members. And the countries in dark blue, of course, cannot be members because they're not members of the European Union and therefore were not members of the group that founded this. So what I'm coming to here is that when looking at a question of freedom to operate, just saying Europe doesn't necessarily discreetly answer the question. You need to understand what it is about Europe that you're interested in, specifically what countries about Europe that you're interested in, because which ones of those are of interest will determine what sort of rights you're going to look at. So let's move on to the next part of the question, the European question, which is which patent rights are we going to talk about once we've decided on geography? Because patents can be obtained in Europe by a number of routes. Now, there are national patents in European countries, which are obtained by National Patent Office filings or through the traditional EPO filing, which results in a bundle of national patents. There are regional patent rights that are coming in now because of the creation of the unitary patent, which comes through the EPO, and if selected, is not differentiated by country. It is a single right. And then there are the national utility model patents that are also available by national patent offices, but not via the EPO. And all of these can either be obtained by direct filing in any of these national patent offices or by direct filing at the European Patent Office or through the national or regional phase of a PCT application. So ultimately, you have to then try and decide not only where you want to look, but what you want to look at. And traditionally, you will generally group all of these together. But because of these different routes, it also tells you what other things you need to look at, whether you need to look at PCT applications, whether you need to look at European applications, or whether you need to look at national applications as well. Because if you're in very specific countries, relying on just the EPO or just the PCT to tell you what the answer is may not be sufficient. So ultimately, when starting a freedom to operate study in Europe, you have to make these two decisions. What do you want to look and where do you want to look? What rights are you going to assess? And where are you going to look for them? Because without that information to guide you, as you can see, you can ultimately end up looking in many countries for many different rights. And whether or not these are important or not will depend on what your challenge is. So in a sense, the takeaway from this is to think a little bit more about Europe and the individual countries within it, but recognize that there are regional rights that are now coming into play in patents that you're now going to have to pay attention to. And obviously, which individual countries and how you approach them will be part of the analysis. So with that background, I'm going to finish up the, what do we mean by Europe, the what and where part of this. I will now hand over to my colleague Katarina, who will explain a little bit as to why you need to look at this problem in the first place. So Katarina, over to you.
Thank you, Martin. And before I go into why would you need to look into freedom to operate, I just want to mention that you can type any questions you have for us, and I hope you have some. You can type them in the chat, and we'll be very happy to answer them. So now let's go into why would you need a freedom to operate. It's actually all about risk management. You want to launch a product or a service on a market. And of course, if it would infringe any IP rights, then you are the responsible one, and it may have very ugly consequences. So having a properly done FTO, taking into account all the peculiarities of Europe, and you now know that there are many, allows you to minimize the risk that you would get into IP infringement. And you have to look at various phases of the product and the life of the product. So you have to look at the production phase and also production country or countries. You have to consider where you transport or store your goods, because even in storage, you might be responsible for IP infringement. And by storing goods in a certain country, you can infringe IP rights in that country. And then, of course, the country where you offer and sell your products or services to customers. So all this has to be considered, and especially in Europe, you may have different situations in different countries. The advantage of knowing the risk is that you can then take active steps to address the risks. There are various strategies. So you can decide for designing around. So adapting your product or service so that you get out of any risky IP rights scope, and you may actually design around based on information that already appeared in the IP in the FTO. You may also design around based on a different search, a separate search, which can be also carried out. And you may also be able to design around so nicely that you produce a solution which is patentable, which would improve your position further and keep your competitors in a safe distance from any product or service of yours. Designing around will always take you time, will delay market entry, and will cost you money. Another strategy to consider, or another step to consider, is licensing in or acquiring the risky IP right. That can be fast, but will very much depend on who is the owner of the respective patent right. So there are some patentees that are only too happy to license out. There are some, such as your direct competitors, who would not be very happy to give you a license. But it's an option to consider. If you really don't like the IP right, you can consider filing for revocation. That would again require to have a nice story. On the other hand, if you file for revocation, the revocation procedure on its own takes some time, and also you may need to file for revocation in different countries, or you can file centrally. That depends on where you are in the procedure, how old the patent is, whether it is a unitary patent or whether it is a national patent. So lots of interesting issues there. And if you have a request for revocation in place, it may allow you to already launch in some countries, because in some countries this is a reason for not issuing a preliminary injunction. In other countries, such as in my country, no one cares whether the patent is subject to revocation procedure. So you have to be careful in some countries more than in others. Another option, not always available, is changing the geography. By changing the geography, I mean looking at other countries for production where the patent situation might be more favorable, looking at other countries for storage of goods, looking at countries where you really can get to market or not, or postponing market entry in some countries until the situation is resolved by any other possibility. The last option is taking a calculated risk. So knowing that there might be a risk, but deciding that you will go there. Anyway, in this respect, it might be useful to know that some European countries and also the Unified Patent Court allow filing of protective letters that allow you to be involved in discussion about a preliminary injunction, so you are not taken by surprise by an already issued PI. In some countries, again, it's not possible to file a protective letter, so you always need to ask a local patent attorney, and that's where actually the advantages of IPEX come in. Talking about the advantages of IPEX, I would like to pass on to my colleague Maciej Dylik from Poland, who will tell you much more about how to actually go about obtaining the FTO.
Thank you, Katarina. Yes, now let's talk about more practical approach, how to really realize, and from the customer, from the business side, how to approach the FTO. It can be summed up in a rule of 3 Ws, because when you are going to go to any kind of patent attorney and ask him a question about FTO, about if your services or products will have problems with some patents on given territory, there will be 3 questions to answer every time, so better prepare in advance. These questions are what, where, and when. What relates to what are your products, what are your services. We are patent attorneys. We have our technical background most of the time. We know some technical stuff from our education, from our daily life, and so on, but we need to understand your product. We are not working at your companies, so please remember that the better you prepare your materials, the better we understand it, the better we can narrow the search down, use better keywords, better IPC classes, the less we will have documents to look at, which means probably cheaper, probably quicker, and most of all, the better we understand your product, the better will be answered. Just to give you an example, here we have a scooter. Most of all, quite simple design, easy. Even from this picture that we have in front of us, we would more or less understand how it works. But if you provide us with info that you want to produce such a scooter, these are the parts listed that you buy, and these are the parts that you have designed yourself, and you are ready to provide us with blueprints and additional info that may be needed, yes, this is good. We will understand it very well, and the results of the search will be really on point and very useful for you in the future. On the other hand, if we have a car schematic and you come to us and tell us, oh, we are producing new brakes for the car, and these will be good brakes, but we have not finished our work on that. So please tell us if we can produce good brakes that are cheaper. What kind of answer would you expect from that? We would have to check every single brake and give you a list of 256 documents relating to patents that are still valid and relate to any kind of car brakes. But this is not what you come for. So please always remember, prepare materials referring to your product. The other question is where. As Martin noticed before, that there are different kinds of Europe. You may not also think about Europe as a whole. You may just think about specific countries. And this is very important because sometimes we get asked about, okay, let's do FTO for the whole world. We say, okay, 5 or 15 million euro, 3 years to provide you with results. Why? Because there are 100+ million documents of patent nature from all over the world. Some of them are past, but some of them are still valid. So yeah, if we are to check all world, it will take time. So know your market. And with that, if, as given here, you know that you are based in Scotland, you have factories in Italy and Finland, you export through Amsterdam, you sell to Spain, Poland, and Croatia, okay, then we have a list of countries. We can think if you are transporting by land through maybe other countries, so the list may grow. And you also say that you are thinking of Canada and Brazil. This is a very good list, very nice, very pretty. We can work with that. We can get a number of countries. We can see how many documents are relevant for the topic that you have given us earlier with while answering the question, what? So now with where, yeah, we'll be able to really pinpoint how many documents will be necessary to check, to be checked. And if you just come to us as a bad example, asking, okay, please find us important markets for us, we are patent attorneys. We do not know your business very well. So what is important market? What is important market for company that produces planes? What is important market for company that produces and sells bicycles? What is important market for company that produces hand cream or any other product or service? Yeah. So you know your business, you know your market. So please also prepare it in advance because it makes all of our lives easier at the negotiation stage and later on also when we actually do the FTO search. Lastly, when? Always remember that checking the documents takes time. Be it 3 minutes, 15 minutes, or an hour. If we have to check a couple hundred of documents, it will take time. So after we finish negotiations, after we agree on the scope, subject, price, please don't come asking if it will be ready for yesterday, for tomorrow. Yeah, because you releasing a product, you have some kind of business timeline ahead of you. And as an example, if you have started producing in Norway, but there is a fair in Paris coming in a couple of months, and afterwards you will enter Austria, Germany, and Denmark, but maybe Swedish is at a later stage, okay, then we know we have to immediately check Norway. We have a little bit of time for Paris, which is France. We have quite some time to check Austria, Germany, and Denmark. And Swedish can be done even later on. This is very good. This is very nice. This is very constructed, very organized. We can do it immediately, but always please remember, each document may be available online or not. Each document may be easily classified as non-important or can be really hard to assess and may require contact with a local patent attorney. So we cannot know this in advance. So please give us more time, because if we have a convenient window of time to perform such an FTO search, yeah, it will at least not cost more than it should. Because if you want super fast search done, okay, we can drop everything, but it will be really problematic for your wallet. Yeah, and don't expect the results on the next day. Miracles can happen, but it's better to expect them. Yeah, and lastly, why to choose Apex? If you are going to perform entering of the market in many countries, it would be good to check each and every market for potentially patents that you could infringe with your product or service. So imagine entering 15 countries, finding 15 patent attorneys from 15 different countries, negotiating 15 times terms, conditions, timelines, waiting for 15 different results, and dealing after that with 15 different invoices. If you come to IPEX, we have a broad network of highly experienced and tightly cooperating patent attorneys. So you have to come to one place, have one conversation, one negotiation. Then we have highly experienced team of European patent attorneys and European patent attorney trainees. We do not outsource our work outside of Europe. So we know our local here playground, as to say. And we are doing a lot of FTO searches every year. It's measured in hundreds, not 3 nor 5. It's measured in hundreds within IPEX. So yeah, we can do this. Our experience here is really nice. And the best thing for you is that you come to IPEX, we do the search, and if anything comes up in Portugal, Spain, or France, we won't make a person from Germany or Czech Republic to answer all questions about local conditions, local case law. No. If we see a document from Norway, we'll go to Norway. We'll find a patent attorney from there. We have already a list of good patent attorneys there. We work with them. So yeah, it will be done immediately. You will not have to wait for the results. And then when you see results referring to different countries, find each and every patent attorney from each and every country. So yeah, this is one place, one discussion, and one group of results that will be discussed by experienced patent attorneys referring to local countries, which I think is very good for everyone. And thank you for your attention, and back to Rob.
Thank you, Maciej, and thank you to all of our speakers. I'm hoping you can hear me now. I've given up on my frozen video, but hopefully you can all hear me. I can see some nodding, so that's good. So we do have just a couple of minutes for questions. So if anyone does have any more questions, please put them in the chat box. But first of all, thank you very much to our speakers for that fascinating overview of the European system, what freedom to operate searches are, and why you need a European provider and European patent attorneys to do that for you, and in particular, Apex. I did have a question here that goes back to your section, Martin, and it's regarding our fantastic new European patent system, in particular the UPC. The question is, if you are going to be selling your product in one of the countries which is covered by the UPC, should you be searching just that country, or which is the only country that you are planning on trading in, or should you be looking at other countries that are covered by the UPC as well?
So an interesting question. You know, how do we consider risk in the terms of the unitary patents, the UPC? There are two issues really to consider. One is that currently the UPC, the court, has jurisdiction over unitary patents. That's patents that have come through the EPO and have what is called unitary effect. They're a single right that covers all of the member countries that have signed up. It also has jurisdiction over European patents that are in existence that name individual countries, the traditional bundle of national patents. And now at the moment, it's possible for those to be what's known as opted out. You can take them out of this system by a specific act. And that's a transitional provision. But at some stage, that's going to go away. And the Unified Patent Court will have all of these patents considered. But the question here is where the patent has effect. So what you're looking at is at what point can the patent be used to control your activity. So if your interest is Germany, then you're going to have to look at German national patents, German utility models, European patents designating Germany, and European patents with unitary effect. So this is one of the things to understand. This is why picking the country is important, because it tells you which groupings of patents you need to look at. You could contrast that, for example, with my home country, the UK. The only patents you can get are national patents that have come either through the UK Patent Office or as the validation of a European patent. So how you handle the unitary patent still comes back to the question as to where you are interested in the effect of a patent. Now, if you are at any point going to act within a country covered by either a unitary patent or a patent that's covered by the UPC, then you have to consider that's what's the potential, because the potential there is going to be that if it is possible to be covered, then questions certainly of validity could be handled somewhere different. The central division of the UPC can handle questions of validity, can also handle questions of infringement, but at the moment, the thought is that that's handled in the local division where the infringer takes place. So the short answer is that the risk issue with the unitary patent is partially that the validity is going to potentially be judged by a new system, that we still have to find out how it works. We know the rules, we know the law, but we don't know how it behaves because it's only just started. So there's always going to be some uncertainty about that. In local areas where it's a local division of the court, they are going to apply, again, the rules of the UPC, but they're probably going to do it with some local approach, which is understandable. And again, going back to Germany, we know how the German courts behave quite well, and they've got a lot of experience here. You would imagine that it would be a variant of how they're going to behave for the unified patent, albeit operating under unified patent rules. Others could be quite different. So that's not really an answer to your question, but I think it illustrates the issue we have to look at. And the way you look at it is by going back and saying, where are the countries of interest? What are we going to do and where are we going to do it? And then we build this question on top of that. And the UPC is one of those.
Excellent, and a good example of why it's important to speak to people who are experts in the European landscape and to understand where you should be covering, how you should be doing a freedom to operate search. We have gone over our time, so unfortunately no more time for questions. But if you do have any questions or you'd like to know more about what we can do for you, then our contact details are on the screen now. So please do get in touch and we'll be very happy to put you in touch with one of our experts. So again, thank you very much to Katerina, Maciej and Martin. And thank you to all of you for attending today's webinar. And we look forward to seeing you in future webinars or speaking to you in the future. Thank you very much, everybody.
Bye.
Goodbye.